It's actually satisfying too when you find out they're guilty, because then you just have that door closed. You know that this person's never going to be innocent.
Powerful revelations from a lawyer who once fought to overturn wrongful convictions. Welcome to Make Your Case, the podcast where attorneys break down the most impactful cases of their careers and the stories behind them. I'm Joe Douglas, longtime investigative journalist and founder of Clear Eyed Media, where we produce legal videos that help lawyers win cases and reach better outcomes. Today's guest is Utah personal injury attorney Kurt London. He shares the challenges of interviewing people who don't want to talk, the emotional aftermath of wrongful convictions, and the one moment during a deposition when opposing counsel completely lost it. Kurt, thanks for being here. And if you could go ahead and introduce yourself and tell us a little bit about your experience in law and what brings you here.
Thanks for having me, Joe. My experience with law actually began really early. I'm from California. My dad's a judge. So I knew from an early age I wanted to get involved in the legal field. So I geared my entire education towards that. Moved to Utah, went to school here, went to law school here. During law school, I worked for a nonprofit called the Innocence Project. After law school, I worked for the Innocence Project for 2 years as a staff attorney. The individual chapter I worked for is called the Rocky Mountain Innocence Center. They break it by jurisdiction kind of boundaries. So we covered Utah, Wyoming, and Nevada. After doing that for a couple of years, I decided to get into personal injury, which I've been interested in for a while. I was involved in a motorcycle accident right before law school that required a back surgery. So once I felt like I'd done enough service with my law degree, I switched to personal injury, and I started working with one of the largest law firms in Utah that has personal injury. I switched to one of their competitors, did that for about 4 to 5 years, and then I opened my own personal injury law firm about a year and a half ago.
The Innocence Project. Tell me about that. What got you into that? And is there any like a notable case or cases that you worked on that kind of stick with you?
I think what got me initially interested is just my dad being a criminal judge in California got me interested in the justice system. And there was a position open for some student interns at the local chapter, which is the Rocky Mountain Innocence Center. And how they do it is they actually give you a caseload. So you're able to work on cases as a law school student, which is really rare. During my time there, I had 4 clients total because these cases take a ton of time. You're basically going back 3 decades, reconstructing a case from the very beginning, redoing the police investigation, figuring out what went wrong to try to figure out if there actually is a case of innocence. If there is not a case of innocence, obviously you close it, because that's not the whole purpose of the project is to find people who've been wrongfully convicted of crimes they didn't commit. I've had a couple notable ones really made a huge impact on my career. I could talk about them since they've been filed in court and everything's public. Antoine Jones in Nevada is probably one of the biggest ones. That was a drive-by shooting case where a corrupt detective didn't like Antoine and wanted to pin the crime on Antoine. So he went around telling all the witnesses that if they didn't pin it on Antoine, he would pin the crime on them. And after we reconstructed that, there was no indication in that in the file at all. We went around and got recantation statements from the perpetrators, all of the witnesses. I think we had like 15 or 16 affidavits. We had a lot, but basically everyone said, no, it wasn't Antoine, it was someone else. It was pretty obvious who the actual perpetrator was. Everyone indicated that this detective was the one who had pinned it on Antoine. But because of how slow the justice system is, it's still being litigated. I mean, we've gotten those affidavits about a decade ago. So it's still going up and down the court system in Nevada right now. But that's probably the one that's made the biggest impact on my life, because he was a young kid when he got convicted. He was like 16, and he's still in prison. And this is back in the 90s. So he's been there for a while.
So he is still in prison.
He is.
Despite the fact that several people have come out with evidence that he is not guilty.
Yep.
So how did you said you go around and get these statements. How does that process play out? And what are the challenges you face when you do that?
Oh, that's probably the biggest challenge. So when you're going through court documents, you write down every single person's name anywhere in the file because you don't know how they might be involved. Once you've done all of your research, you've read every single piece of paper, every single document available in the file, every photo, every video, then you start approaching the witnesses, usually from least important to most important. And it's been a couple decades. You're knocking hundreds and hundreds of doors, going to old addresses, trying to track down aliases, parents, cousins, whatever, to finally be able to locate this person. And once you locate them, you try to have a sit down conversation with them, interview them like you would normally about a case. What happened, what'd you see, what do you remember? And if they have any pertinent information about the case, then you get it written down in an affidavit, because sometimes they disappear. They're really hard to find. People don't want to be found a lot of times, especially when it involves a crime. And then you kind of work your way up to the most important witnesses, usually the actual perpetrators, the person who actually did the crime or has firsthand knowledge about the crime. Sometimes when you approach them, they confess because it's been weighing on their heart, for the last 20, 30 years. If you're lucky, that person's in prison for another crime. So they're a lot easier to find. They're a lot easier to interview. And you could just schedule a time to go down to the prison and hopefully they talk to you. But by that time, you have all your ducks in a row. You have all these affidavits, all these recantations, and you know exactly what information you need to get from them. Sometimes it works, sometimes it doesn't. In this case, the actual perpetrator was deceased, but there were several other individuals in the vehicle with him that committed the crime, and they all recanted and indicated who actually committed the crime.
And where were they?
A couple of them were in prison, so it made it really easy. The other ones, they're still in Las Vegas. People seem to not leave Las Vegas once they're born and raised there. But again, sometimes we would go down there for a week at a time and we knock on 700 doors. It's just knocking on door after door after door, trying to knock off or cross off bad addresses. Every once in a while, you get a family member, they give you a new address, you got to go to that door. Sometimes you get a phone number or an email address. But it's really just following the breadcrumbs, trying to piece this together.
In the Vegas heat is probably punishing. Right?
Yeah, I'd always made it a lot more fun when it's 110 degrees.
Yeah,
You're walking around knocking on doors.
I was a reporter for years, so yeah, I've done a lot of door knocks, and I can only imagine 400 doors around the Vegas area is blistering, literally and figuratively. But
Yeah.
wow,
And
well,
you never know how they're going to receive you either, because people don't like to think about bad things they did in the past, especially if they can get in trouble for it now too. So it's always a complete mystery as to how that conversation is going to go.
Now, forgive me because I'm not a lawyer. Did you have subpoena powers? Were they compelled to talk to you in any way?
No, because we hadn't even filed our case. So in order to file an innocence claim, you have to have very strong, clear, and convincing evidence that the person's actually innocent. In order to do that, you need to have the affidavits. So we didn't have subpoena power. Nothing was filed in court. We were just doing our investigation. So yeah, they didn't have to talk to us at all. Sometimes that would happen and we'd subpoena them later after we were able to file the case. But we've had cases where no one would talk to us and we just had to close it because we don't have subpoena power. We can't just file a frivolous lawsuit hoping it's true. Yeah, it makes it infinitely harder. You get as a reporter, you're just hoping people will actually be honest with you.
Yeah, it's incredible the amount of pressure that you're under in both worlds. They're just completely different. But so you're under you guys are wanting to basically you believe that this man is not guilty. So you're operating under this sort of it's like an ethical or moral drive. Would that be correct?
Yep, totally.
Yeah.
That's exactly right.
And then also, not to be glib, but the organization exists and gets funded, right? So you guys have to get points on the board or prove your worth in some ways. Is that part of it, or what is that? Is it just sort of like it's a given that some are going to win or some are going to lose?
Yeah. The Innocence organization, the Innocence Project, survives off of grants and donations. So the government doesn't fund it. We might be able to get some small government funding, but it's all individual donors, and it does help to get exonerations. Just in terms of sheer volume, though, you're going to have some exoneration. So there's not like a drive to get some wins to like shout out on social media. There's just a drive to get that person out of jail or prison if they're actually innocent. And it's actually satisfying too when you find out they're guilty, because then you just have that door closed. You know that this person's never going to be innocent. There's no way to prove it. Now we can move on to the next case. So it's satisfying one way or the other. In the Rocky Mountain Innocence Center that covers Utah, Wyoming, and Nevada, they have about 50 to 60 active cases at a time. But there are projects all over. I mean, California's got like a half dozen innocence projects. New York's the biggest one. They've got a huge staff. But in total, just on DNA exonerations alone, there's a few thousand in the US. And a lot of states have put a moratorium on their death penalty because, like in Chicago and Illinois, they found that they had executed innocent people. It's a little hard in the 70s and 80s when you don't have DNA evidence or you need to have like a significant amount of semen or blood to test it. Nowadays, you need one simple cell. Someone touches a surface of a computer, they can DNA test that and get your DNA. So if there's like a knife available, a gun available, something left by the perpetrator glove, we can go back and swab it, get that single cell, and now find out if they're innocent or not. Back in the day, it was usually just one witness statement or very circumstantial. So there's just a lot of people. Experts believe that there's probably about 5% of our prison population is actually innocent of the crimes they committed. So there's just a lot of work to do, and you're going to start getting exoneration just by doing the work.
So when you went into this and before you went to law school, does any of this come as a surprise to you after doing this or not? Or what was the most surprising sort of discoveries you made at this point in your life going through this position in the Innocence Project?
It's actually the same feeling that I have towards personal injury. You believe that this system is in place and it works flawlessly, but in reality, it's a giant machine. And that machine does what it does and it moves forward and pushes forward. And sometimes accidents and mistakes happen. So in the justice system, I grew up with my father being a judge thinking that, well, if someone's innocent, the cops wouldn't have arrested him, the prosecutors wouldn't have brought a case, and the juries wouldn't have convicted him. Now knowing what I know, that's just the huge system. Once someone gets on their radar, they just get pushed forward until they get a win. Most of the time that person's guilty and they get what they deserve, right? They broke the law, there's consequences, but every once in a while, just because of the sheer volume and the intensity of the system, you're going to have people who get caught up that are actually innocent of that crime. Same kind of thing with insurance companies. You have this big system. Sometimes they do what's right and they pay out fair value for a claim, for a vehicle or for injury. Mm-hmm. But a lot of times people get caught up. They don't get the right value for their claim. So same kind of feeling. That's actually what turned me on to personal injury, aside from my own accident, was it has a very similar feel where you're standing up for a victim against this big giant system.
Yeah, and so is there a particular case that comes to mind from your personal injury practice that sticks out as something you've learned a lot from or is notable in your career?
Probably the biggest one is with my friend Shane. He was involved in an accident about 6 years ago now with a large restaurant company here in Utah. He was at a complete standstill. He was waiting to turn left into a hotel parking lot, and one of their executives rear-ended him at a high rate of speed. And Shane ended up having 5 different surgeries. He had 4 back surgery and a knee surgery. And it was a really emotional time for Shane. He was unable to work. He couldn't even walk. The treatment was taking a lot longer. His healing process was taking a lot longer. And this is a guy who's really active. He goes hunting all the time in the mountains. In Utah, we've got these big old mountains. Really active, comes from like a law enforcement family, to a guy who's in a wheelchair or using a cane to get around. And the insurance company just thought he was making everything up. He thought he was making his injuries up. He thought he was exaggerating. He thought he didn't need the surgeries. And just being able to tell that story, to be able to get a good resolution for Shane, was probably the most difficult case that I've had to deal with, but I've learned the most from it, just with how intricate everything was. But Shane and I are still friends today. I mean, we've texted a couple days ago. We text probably once a week or so and catch up because of how close we became during that whole process. It was a few years of literally knockout, drag-out fights with opposing counsel, his providers, everything. It was just an extremely difficult case.
Well, take us into that. What made it difficult? What were the claims being made? What did you have to overcome, particularly in terms of just the story and like his claims and them Was it a big tit for tat, endless struggle, or what did you have to overcome there?
Just from the beginning, his medical treatment. So he had two back surgeries that failed. So because of the back surgeries that failed, they gave him foot drop, which made it difficult for him to walk. Because of how he was walking, it blew out his knee. So he had to have a knee surgery. And he had to have two back surgeries to redo the ones that failed. Um, on top of that, Shane's recollection, it was a really big hit. He hit his head, so it was hard for him to kind of remember a lot of the details. But that's what they were using against him. They were thinking that he was exaggerating everything, um, that the hit wasn't as big as he claimed it was, that he was not injured because he drove himself to the hospital right after the accident. They thought he was fine. The surgeries that he needed, they thought it was, because of the surgeon. The surgeon should have done the surgeries in the first part. And then when we got to the actual negotiations or mediation in litigation, and this is after we've gone tit for tat arguing about everything, it was really hard to tell his story because he used to be a miner in Tennessee and he made quite a bit of money and he moved back to Utah and took some time off to be with his dad. So the time he got hit, he was technically unemployed. So it's really hard to prove lost wages when you have someone who used to be a miner, took like a year off to be with his dad, and technically had no lost wages. So it was really hard to prove the impact this accident had on his life. When on paper, it looks like he's unemployed anyway, so he wouldn't have any impact in lost wages. Um, he's making up these injuries. He doesn't remember the accident totally, doesn't remember exactly how the accident impacted him. And then the lawyers are just going to be hitting every single thing on that. So they had like 8 experts lined up on this case. They spent so much money trying to literally nitpick every single little detail of a story, his treatment, his impairments, his future lost wages, his future medical treatment, everything. And it got really heated in the mediation, but luckily the mediator was able to navigate it, where we were able to get it settled right before trial because Shane's emotional toll, it was a roller coaster. And I honestly don't think that he could have mentally handled a trial, and he didn't want to go through that anyways, too. But luckily, mediation, we were able to finally piece it together for opposing counsel to finally understand the total impact of the accident, to finally get the value that he needed out of it so he can kind of get his life back on track.
You're satisfied with the outcome of the case?
Oh, yeah.
Can
Yeah,
you
it was
talk
great.
about the size of the settlement?
Probably not.
Okay, that's fair. I always got to ask. But how
Yeah.
did you do that? I mean, it sounds like a formidable. Like what's like get a little more detailed here about like what are there some even just one or two of the things that they were pushing back on. What was the challenge, and how did you specifically overcome some of those challenges?
Just the biggest thing was just his impact on his actual health. So his impairment, they didn't believe that he was impaired. They thought that one, he wasn't injured in the first part. Two, the surgeries didn't fix anything because it didn't need to be fixed. And three, he just didn't have any impairments because of one and two. So he had no future lost wages. He had no permanent impairment. He didn't need to use a cane to walk around. Um, but when we lined everything up and showed them how the jury would view the story, how a jury would see Shane, and the witnesses that we had, I mean, some of the witnesses we had were law enforcement officers that were his friends and family that could testify about it. They've known Shane for decades and decades. We also had a lot of photos. I mean, Shane, like I said, was an active guy. He's hiking in these mountains, hunting elk, hunting deer. He had no problem with that. But now he can't even drive in a car longer than 10 minutes because of his back pain. And that's just driving in a car. Um, so I think piecing that together, kind of feeding him to him piecemeal and showing it in the light that a normal person, a normal jury member would see, is finally what got them to click. And I think that they realized too that with their legal strategy lined up, they were going to have a significant amount of bills for that trial. With 8 experts involved, I mean, you're probably looking at a few $100,000 just in expert fees to get them to testify, let alone what they've already paid with their opinions and everything else. And I think everything with the mediator's help was able to piece that together for them to kind of see the bigger picture of everything. once that happened, then it was a fairly easy discussion. But up until then, I mean, they thought we were lying about almost every single aspect of that case.
So would you say it's the combination of the testimony from folks who know him and like the images of just, hey, before here's what my client could do, and clearly afterwards, is it kind of like the culmination of all that, or is there any one particular part of that that you think really pushed it over the hump?
Um, I think the answer is yes to both. I mean, we were able to tell his story and show the human side of his story. So one of the witnesses was his daughter. I mean, she was just sobbing in the deposition about how different Shane was from before and after. Um, he's unable to play with the grandkids. He has no stamina anymore. He's depressed, difficulty hearing, and just showing the impact that it had on the family too, not just on Shane, to kind of let the other side know that this isn't one man lying. This is him living this trauma, and it's also impacting everyone in his sphere, including his grown kids that in their 20s or 30s. So we had one of them, we had to fly him in from Idaho to testify, and he would go hunt with his dad. And I think showing those pieces of elements, pieces of this human being that's now broken, I think is what we're able to finally show and use to kind of push the case forward.
Yeah, and that's great that you did that. The other aspect of it I run into in my own work is you have this, obviously you have like the testimony from people who know him versus sort of like the need to back it up scientifically or through medical records. And how do you handle that challenge? Because you don't want, potential jurors or mediators to think, well, of course these people are going to say this person could do all this stuff beforehand and now they're damaged because he stands to gain financially from that claim. So how do you balance that with the need to like to show that it's real medically?
Um, the thing with Shane's treatment is he already got the treatment, right? They're already paid. The surgeons and stuff, they don't have a dog in the fight. They don't have any incentive. We're not paying them extra money to say X, Y, and Z. Um, in Utah, we can't direct treatment, so we barely talk to the providers, which is a good thing, I think, in my opinion. So it's not like we're having them say a certain thing. So it was really easy in our case to show his complaints, which were consistent over the years, to the medical treatment, which were consistent with his complaints, and then just plug in the human element, which matched almost exactly of what he was complaining about this whole time. So the leg drop, the low back pain, well, that makes sense why he can't walk anymore, why he can't drive anymore. Um, the irritableness, it's a lot of the pain medications he was on. It just correlated perfectly. So it was really easy for us to show on paper what he went through, what he received as treatment, and then plug in the human element to show exactly how that impacted him and his sphere of friends and family. So in this case, we really didn't have a problem with it. It really
Mm-hmm.
matched up really well. Um, but that's just because he was open honest with his providers. For Shane's credit, he was very vocal about what he was feeling all the time. I mean, we would communicate on a daily basis for years on this case, and like an hour-long conversation every morning about everything. And I think that really helped his case because it was documented well within his medical records.
Yeah, that's great. And so, as an attorney, and as you're thinking about how to present this in mediation, because it didn't go to trial, how do you do that though? Because that's one of the big issues with storytelling that I kind of dovetail into is, you often are. It's like it's a cliche to say drinking from a fire hose, but in most legal cases, you are a discovery. There's usually a tremendous amount of evidence and stuff at play. So now, as the storyteller, as the attorney, what do you do? How do you present that? Do you present sort of the medical information first and then go into the testimony? Do you do testimony? How do you decide the order of how your case is going to be presented? Do you kind of pepper it in throughout? What is your process for that?
That's a good question. And we took a different approach on this case where we thought less was more on the medical side. So when we hired our experts, we only hired two. Right? Opposing counsel had like eight or nine. We thought that the biggest strength to our case was his actual story. He was able to articulate it really well. I mean, he had scars all over his body from these surgeries. You could just watch him walk with a cane, You could see him get out of a car. I mean, I would watch in our office window in the parking lot, see him get out of a, he didn't know I was watching, but just to see how he was. And he struggled a lot. So we decided to take a step back from forcing a lot of experts down the jury's throat to getting a lot of experts to try to provide an opinion. And we used his story, and you're exactly right, peppering it in with the medical facts kind of throughout was the best approach because we really didn't need to use experts to prove how it was impacting him. It was pretty evident from the testimony from his kids, from his friends and family. Um, I mean, even his partner, she was sobbing in her deposition by it really impacted their relationship. They used to go on date nights all the time. They were romantic all the time. To basically, she has an invalid now that she's dealing with, and we just thought that that communicated the accident injuries better than say someone we would pay $10,000 to write a report and to kind of provide an opinion on X, Y, and Z from the medical records. So we would use his story and just basically back up their testimonies by the actual medical records. So we almost flipped it and relied more on the human story than the actual medical records and bills.
And so, how you actually had to fly folks in to testify, and how did that work, sort of logistically, and who pays for that? This is something I personally am just curious about how that works.
Yeah, in this case, we had to fly a few people around. So it takes a lot of planning, depending on who's flying whom. So for Shane's son, he flew in from Idaho because opposing counsel wanted to depose him in person. They would cover the cost of it. If it was us that wanted it, then we would have to cover the cost of it, and it would be an expense on the case where we
Mm-hmm.
would just get reimbursed. Luckily, most of the travel was covered by opposing counsel. Um, but usually that's generally how it works in all cases. If we have an expert that we need to fly in, we would cover that. Or if we needed Shane to go somewhere to get a special scan or something, we would cover that.
Mm-hmm.
Um, or be placed on a lien, and then everyone would get reimbursed at the very end from the final settlement.
Right. And then this is because there's a number of people who may watch this or listen to this that are not lawyers at all. That's what, but it's, when when they're deposed, everybody gets a chance to depose them, correct? Or is it, so they're paying to have the person flown in, but everybody gets a crack at them.
Yep. So you're in a conference room, it's that witness, or your client, or the other at-fault driver, and it's both sets of attorneys usually on either side of the table, and you have like a court reporter, and whoever picks to depose that person gets the first line of questions, and they usually broad open-end questions. In Utah, you get about 6 hours for these depositions. You can get more if you request it. Um, and then it's the other person's turn once those line of questions are done. So if they are the ones, the opposing counsel is the ones who wants to depose, say, Shane, then we would let them ask their questions, and then we would ask follow-up questions. And then after our follow-up questions, maybe the other attorneys had some other questions. And you basically just go back and forth until you both have exhausted all your questions. And then that's when the deposition comes to a conclusion. So that is your one and only time to depose that person on record. It's not to say you can't contact them. So I can contact witnesses at all times, to ask them questions. Doesn't look great in court, though, when opposing counsel says, hey, has this attorney called you? How many times have you talked? What'd you talk about? So that's why doing it in front of a recorded interview is the best way to do it. That's kind of how the process works.
Yeah. And so, and again, these are questions for lay people who may be watching or listening is like, are these people paid for their time, or are they just sort of transported and doing this voluntarily effectively?
It depends on the state. Experts are paid by their hour, their billable
Mm-hmm.
hour usually. Fact witnesses, so that's like any normal person. There's usually like a small hourly rate that they can get compensated for. It's like
Yeah.
$18 an hour or whatever. But any accommodations they need, if they're flown in from like far away and they need accommodations overnight, they need food and lodging, that's usually covered by the person who wants to depose that person. But they're not like making a lot of money by showing up to a deposition. That's just their duty. So you request to do the deposition and the interview, And if they don't, then you can subpoena them and send them a subpoena and go after them through the courts. So there's certain ways to do it. Noticing it through a deposition, so asking them officially to do it is just a lot easier, a lot friendlier than, like I said, they can get paid. It's usually a small fee though, really small.
But obviously, from my perspective, subpoenaing someone sounds like it has an obvious drawback. Like you
Yeah.
piss them off
Yep.
potentially. I mean,
That's exactly right. You don't want someone who's angry showing up to their deposition,
yeah.
and a subpoena is usually the fastest way to do it.
So
So
yeah.
even like doctors and stuff, they hate being deposed. We would try everything in our power to get them to show up to their deposition without subpoenaing them. They
Right.
do not take kindly to being subpoenaed. So you better believe it's going to dramatically change their testimony when they're angry with you, right? They're less talkative, they're more combative. Sometimes they show up with their own attorneys. So subpoena is like the last resort.
But then that sort of brings back your Innocence Project work of going door to door in the blistering Vegas heat trying to get people to talk. Does that play a part here? Like
Yeah. I mean, it's
how
it's
so?
got the same kind of feel where um, you try to approach it as a conversation, like you're just getting to know this person. Because usually this is the first time you ever talked to them. This is the first time you ever seen them. You don't know
Hmm.
what they're going to say. Not going to know what they're going to testify to, but you just want to hear them out. So building kind of a rapport in the beginning, introducing yourself, getting to know them a bit more. And then when you ask questions, you're not accusatory unless you need to be later on, but you usually open-ended questions to kind of get them talking and comfortable. Depositions sound really scary to a layperson, but in reality, it's a lot more boring than what you see in the news or
Hmm.
media, YouTube. It's really just more of a boring, really boring conversation. But you want to get them used to that because showing up and having a court reporter and having several attorneys isn't that comfortable, especially in a case like Shane's where the opposing side had like six attorneys. Um, Not all six would show up to some of the depositions, but you had a lot. So when you're walking into a room as a layperson in a room full of attorneys, um, it's really intimidating, really, really intimidating. So I try to calm them down. Um, get them used to the process in the very beginning. I usually set ground rules. Innocence Project, you don't set ground rules, obviously, but you just get them talking about their life, try to get them to open up. So it's a very similar feel, just without the heat.
What's your opening question? You knock on my door. What do you say?
For the Innocence Project,
Yeah.
I should introduce myself. Hey, my name's Kurt London. I work for an organization called the Innocence Project.
Hmm.
We think that you might have seen something about this incident. We just love to talk to you and just see what you remember, if anything at all. That usually opens up one way or the other and kind of go from there.
I like
That's
it.
pretty similar to my depositions. I'll go into ground rules, but I'll introduce myself. Hey, my name's Kurt London. I represent this person. I'm an attorney. You know, this is what I do. This is what we're doing here. I'm sure your attorneys talk to you, but here are some ground rules. It is okay if I go over some ground rules? Yes. Go over those ground rules. I'm like, well, let's just talk about your family. What's your family like? What's your education like? Where do you live? What's your background? That usually gets them to open up. Innocence Project was pretty similar. Innocence Project, though, is getting into the door was the hard part. Right? A deposition, someone's there. They know they're there to answer questions. Innocence Project, you're showing up out of the blue. The biggest thing is they thought you were a cop. I look like a cop. I got told that all the time. So I try to show up in like t-shirt and shorts or something. Maybe that gave off more cop vibes. I don't know, but yeah,
Well, it sounds more interesting than a religious or a sales knock like what you just said. I would be just curious. I'd be like, what?
yeah.
So that's really interesting though. And then like the other thing too is that this is a like as a journalist, I felt the same way. Like it's a really sometimes it's a challenge of getting people to talk, especially in those situations where you're knocking on doors. But then once you're in the middle of a deposition or an interview, what do you do if someone's tight-lipped or they're maybe not even like they're just a little shy or they're not talking or how do you kind of get them to open up if they in the middle of the conversation start to kind of clam up?
It's a good question. There's a few different strategies that I do. You needed to kind of loosen them up. So what I'll do is I'll usually change my line of questioning. I'll just go to another topic, kind of move on. And a topic I know that they could talk more about, that they'll they'll kind of open up more about. And then when I get them opened up again, then I kind of revisit that last topic that they clammed up about. But I do it more gentle, I guess, like kind of just approach it in like little tidbits. So like, let me talk to me about this little aspect of this accident or this little aspect about this crime or, um, like just what do you remember seeing? I try to use my tone too. I'm a litigator. I can be kind of intense. I try to just like use a soft, calm, welcome tone. I try not to get flustered. I also ask them too, like, do you need to take a break right now? In the Innocence Project, you don't because you're at the person's house usually. But for a deposition, do you need to take a 5-minute break? Do you need to go get some water? Do you need to go relax for a minute, then come back and revisit? But between those tactics usually works. Innocence Project, you try to just take it back to a topic that they're comfortable discussing and then revisit.
No, that sounds like a good strategy. And then I like the open-ended questions because I feel like as an interviewer myself, I'd always like want someone to feel like they have power. Like you have someone particularly like where you have a really touchy case. What is your strategy with you? Like if you have someone as like in a sexual assault case who may be a survivor or may have witnessed something really terrible, and like what do you do to kind of break through that awfulness and get them to feel trust that they can talk?
Um, the approach that I use is similar for the perpetrator as to like the victim. People just want to feel validation. Whatever their situation is, they want to feel validated. So they don't want to feel judged. They want someone who's open and honest and accepting. They don't want someone who's accusatory. So you just take that with a grain of salt with your approach, with your tone, the questions you use. Keep using open-ended questions. You don't make judgmental statements. In order to relay that you're understanding and sympathetic, you might restate what they said. Oh, so you said X, Y, and Z happened. Is that right? Oh, yeah, that's exactly happened. Okay, well, why don't you tell me a little more about that? What else happened? Um, because people don't, I mean, when you get accusatory and you get aggressive, our automatic reaction is fight or flight. So people clam up a lot. And you don't want that. You want just to know what they know, to hear what they hear, to remember what they remember, to get their statements. So that's usually the best approach. If, like, you're talking to an actual perpetrator, someone who caused an accident, someone who did a crime, sometimes that works, sometimes it doesn't. And then you kind of just need to change your approach. Usually when you get them locked down, you get them their testimony, you can get a little more aggressive, a little more pointed with your questions, but that's after you've built a rapport. So it doesn't come off as aggressive. And I'm not saying like aggressive with your tone and nature. You just get a lot more pointed with your questions, a lot more yes or no to box them in to figure out exactly what they did or did not do.
Do you ever poke the bear a little bit?
um, yeah, I mean, I've had instances too in the Innocence Project. One of the words that you do not use is the word snitch. Um, the police have snitches. Some people will snitch to get deals, so they'll point the finger at your client. I remember I was doing an interview and I was with a student, a law school student at the time. Usually you're in twos when you do these interviews for the Innocence Project. And we were in prison and we were going to go talk to the snitch. So the one who had snitched on multiple people. It was pretty clear that the government had used this guy as an informant before. And as he's walking into the room, the student leans over and says, "Oh, so this is the snitch?" And he could hear that. And as soon as he heard that, you just saw like this, like he just turned so angry.
Yeah.
It was almost like a light switch. I'm like, ugh, there goes the whole interview. We'll never be able to approach this guy again. He's never going to talk to us. And I've had it before where I poked the bear with opposing counsel in a deposition, and we got into a screaming match because I had boxed his client in. The client was clearly lying. I had, 15 pieces of independent evidence to show that he was lying, pictures, testimony, call logs, things like that. And I was walking him through each piece of this evidence. And at the very end, I said, so based on these 15 pieces of evidence, are you still sticking to your story of X, Y, and Z? And his opposing counsel threw up his hands and said, oh, you don't need to answer that. He's asking if you're lying. So now you have the other attorney testifying, which they're not supposed to do in a deposition. And then he started yelling at me. I started yelling at him. I had my paralegal there. It was really uncomfortable.
Mm-hmm.
um, I should have filed a motion on that, but I didn't. Um, yeah, that one was where I could see his client was getting tense with my questions. And then I think that kind of rubbed off on opposing counsel. So I poked the bear, but instead of getting the bear to respond, I got his counsel to basically do it for him.
That's really interesting. Yeah, there's all the things you got to do to get your case across, and sometimes they work and sometimes they don't. So that's
That's exactly
interesting.
right.
The now the other thing I want to ask you too. This is another one of these sort of like, you know, everyday Joe kind of questions is what's the role of a mediator in this process? Are they there for all the depositions? Do they just show up at the end and look at everything? And where do they fit in with this?
That's a good question. So mediator is an independent party that both parties pick. So usually it's like a retired judge. It's an attorney who's got decades of experience. Um, there's usually a list in the jurisdiction of mediators that attorneys will usually use because they're very fair. They are not involved in any of the process at all. You bring them in usually towards the end. So in Utah, you have to do mediation before trial in order to certify your case for trial. So in order to get a trial date, you have to do mediation. So it's usually one of the last things you do. And you usually have them for like a day or two, and you prep your case. You do a mediation brief, it's called, which is basically a summation of your case. And these guys aren't dumb. They've done it tons of times. They've seen these cases all day in and day out. So you can cut straight to the facts of what a judge and jury would see. So, give them the pertinent medical records, the photos of the property damage. And then their job is to basically facilitate an agreement. So what they're really good at is I call it giving them to come to Jesus. So they
Mm-hmm.
give your client a come to Jesus, or you a come to Jesus about your case. Like, hey, I really agree with the other side about this aspect. It's not great. This is not going to go well in front of a jury. But they do the same thing on the other side. So they say, hey, a jury's really going to love this client. They're really going to kind of connect with this case, and they're probably going to give an award of X, Y, and Z. So you are negotiating. You're in two separate rooms. The mediator can go back and forth between the rooms. A lot of times now it's on Zoom. It's COVID. And you're just negotiating through the mediator. So these numbers are getting closer and closer. Um, the mediator, too, can give advice if you'd like. Just like, hey, so-and-so, based on your 50 years of litigating these cases, what do you think the value of this case is? What do you think we should do? So usually when I mediate, I confer with the mediator. Like, hey, mediator, I'm thinking about doing this move because of X, Y, and Z. What do you think? And, oh, yeah, I agree. I'll go ahead and do that. And usually the mediator, you never see him again. So you see him during the mediation, you reach an agreement, or you don't. That is the only time that they're involved with that case.
Great. That's a great way of summarizing the process. So when you present your case at that mediation hearing, is it generally like just a documented, or is it like a PowerPoint slide deck presentation? Do you use a video? Because I often make videos for attorneys in those situations, but I'm curious about what you do and what you prefer or find most effective.
I found video is not great for mediation. It's great for other aspects of the case, though, especially in front of like a jury and a judge to show like, day in a life or things like that. Usually what I'll do is I'll do a mediation brief. So it's just like a written summation, and it's short. It's, 3 to 5 pages. Mediator doesn't want to read a ton of arguments. They're not there to adjudicate a case. They're there to kind of understand each position. And then, like I said, like I might give them the best photos or the most pertinent medical records. You don't argue with the mediator about the case. They don't really care. So you provide all these documents like a week before. They'll review it so they're comfortable with it. But also when they hop onto the mediation, they might ask you follow-up questions before they even start. So, Attorney London, what about X, Y, and Z? Or they might ask your client too. Tell me a little bit more about this that I saw in the records about how this impacted that. And then once they kind of understand, then they'll go back to the other side and they'll do the exact same thing. So as the mediation's going on, they're picking up more and more clues from the case that they might not have picked up on. But usually for a mediator, brevity is the best. I've found that like if you write a really big brief, extremely detailed, most of the time they just skim over it and they miss a lot of details. So just need to highlight the best aspects of your case.
So, but what are the things that's interesting. You were told me about, you got testimony from family members or folks that knew your client and the emotions that came through from that in deposition. How do you relay that in paper or through the mediation process or in the mediation hearing to a mediator?
That's a really good question. That's probably the downside about a mediation is mediators usually don't care too much about the personal aspects like that. It's more for like a jury. So I'll usually maybe cut clips of deposition, or I'll just tell them. That's usually what I'll do is I'll just tell them in the beginning, hey, mediator, we have these clients. They're going to testify to X, Y, and Z. They're going to be really powerful. They're really credible. I think the jury will really connect with them. They really don't care about those kind of testimonies. They like to know that it's out there and available. But like I said, with a mediator, it's more about brevity. They're more of a broker. Like they're to broker a deal, right? So it's like buying a house. When you have a house sale,
Yeah.
you don't want to know the minute details. Like, hey, the caulking in the bathroom on the second floor probably needs to be redone a little bit. It looks a little gross. No, they want to know, is the foundation solid? Does the roof need to be replaced? It's like the big, most important things. Same thing with a mediator. They want to stick to like the big aspects. So you're right. It is kind of like a downfall with mediator, but I try to bring them up to speed as much as I can throughout the whole process.
So is there a tension of wanting to get the most important facts out without flooding, with too much versus telling a story? Like this is often the in journalism too, there's a lot of overlap. Like you want to make sure that the reader or the audience knows that you have the goods, but you also want to tell a story that they want to read all the way through or watch on television or listen on radio or podcast or whatever. How do you manage that? You with dealing with a mediator versus dealing with a trial of like telling a story is, jazz hands, P.T. Barnum, here's the story, folks, versus here's this fact, here's this fact, here's this fact. How do you deal with that?
Again, mediation is just not the right venue for that. So if you're in front of an arbitrator, which is another form of alternative dispute resolution, an arbitrator is like a private judge. It's basically usually the same kind of person as a mediator, but they actually adjudicate the case. They say, I'm going to award you X, Y, and Z. You can pick to do arbitration to see if that will resolve the case. That's the right time to do that. That's the right time to show your witnesses, to show the story, to show video clips. Mediation, it's really difficult, like you kind of indicated. If you did have video, I do think video is extremely important. I would try to pare down maybe special clips or small clips. I have played smaller clips for mediators. That actually might be a tactic now that I think about it. Just maybe paring down 30-second clips to a minute clip for mediator, because a mediator wants to go from room to room. That would actually be a really good way of doing it. But in reality, it's the emotional aspect. They call it trial by human. You want to present a human case, an emotional person, someone you can connect to, is really for the lay person, the judge and jury. Because when you get attorneys, we've seen these cases a million times. I don't want to say we're callous, but we don't have as much of emotional connection because we've seen it. We can break it down in our head logically and legally to a point where those stories don't impact us as much. That same thing with a mediator. Now, like I said, arbitration, that is a small trial. So you do want to present that. Small claims trial, you want to do that. In front of a jury, you definitely want to do that. In a mediation, like I said, brevity. So that would be a good tactic, though, now that I think about it, just breaking up in smaller clips probably work really well for mediation.
Just so they can get a taste of what the testimony's like versus flooding them with the whole enchilada.
Get a Cliff Notes version of kind of the testimony and the emotion behind it too.
So is it the goal in mediation to kind of, it's like, here's what this is going to look like in trial to show the strength of the case? Or do you feel like they kind of get that by just touching on all those points of...
So that's actually based on strategy. So it really depends on your kind of case. Like if it's a bad case, not a bad case, but you don't think it's going to go over well in front of a jury. You want to kind of show all of your cards and just get it done. You just want to show the bad and the good. You want to broker a deal. You want to move on your way. You want to get your client paid, get compensated. If it's a really good case, a case that's going to, be presented so well in front of a jury, you might hold back a few documents, a few details from the opposing side, a few arguments, because you don't want to also tip off your whole hand in mediation, knowing you don't want to settle, and then now they know your entire trial strategy. So it really depends on the kind of case that you want. I mean, if it's a really great case, you don't want to settle at mediation. You want to get in front of a jury and get them to see your client. If your client has things in their story, things in their case that a jury might have a hard time connecting with, might not agree with, that's when you'd probably present everything in front of the mediator to then kind of broker a deal.
Cool. And so kind of reaching sort of a conclusion here, the like tying this together, like what are some of the, throughout your career and these sort of disparate experiences of going from the Innocence Project to being a personal injury attorney, what are some of the things that are surprising to you that you've learned along the way? Or another way of framing this question is in this kind of a cheesy device, but if you could go back and talk to yourself, in law school or fresh out of law school, what would you tell yourself that you've learned that maybe you should have known then? Or what are some surprises that came at you that others might not know about or even think about?
I think the biggest lesson that I learned is slow is fast and fast is slow. So by taking your time and doing everything right from the beginning, building a case up from the very first day correctly might seem like it's going to take forever, but in reality, it's going to save you a lot of time because you don't have to go back and fix mistakes. You don't have to go back and repair part of your case. You're not making mistakes and causing issues for the case. So in reality, it's going to speed things up by taking your time and doing it the right way, the first way. When I first started practicing, I wanted to go quick. I wanted to get everything resolved fast. I wanted to get a trial fast. But you're going to make a lot of mistakes and miss a lot of details. It's really in the storytelling and the details that makes a case with Innocence Project and with personal injury. And you have to go slow and methodically to make sure you pick up all of those little things along the way. And that was something I think that just took years to finally understand.
Good. Do you think technologies help with that?
Yes. I don't think AI is quite there, but you could use AI technology to scan a lot of these documents, to write some summaries, summations, to get you up to speed faster. There's a lot of different things you could do, just like video too, right? You can incorporate into your case to be able to accomplish the same thing quicker. I think AI is going to be game changing. They have all these products out there to try to pitch it. I don't think we're quite there to be able to rely on it fully on the legal field, but I think in a few years, you're going to be able to do cases faster without missing anything using AI, like purging through 1,000 medical records, or trial depositions or testimony. I think AI will be really useful tool for that, but not quite there yet.
Yeah, I've kind of had a similar experience myself. That's interesting.
Yeah.
So cool. That was great, Kurt. Anything else that you want to add or anything else that you really wanted to get off your chest?
No, it's been a great discussion, Joe. Thank you so much.
Again, that's Kurt London, personal injury attorney in Utah. Thanks to him and to you for joining us on Make Your Case. If you like this episode, hit subscribe so you don't miss what's next. And if you're an attorney looking to present your case more effectively, whether for mediation, settlement, or trial, head over to cleareyedmedia.com to see how we help legal teams turn facts into compelling video stories. And if you're a lawyer with a case or experience you think would make a great podcast episode, email me at joe@cleareyedmedia.com. I'd love to hear about it.